Good morning, and welcome to Talk of the Town on 99.7, 1450 WHTC and WHTC.com.
And welcome to Talk of the Town for this Thursday, May 14th. I'm Gary Stevens. Brief sliver of open line time following the 10 o'clock news. Patty Vandenberg will begin in less than an hour with what's new around Holland. Kathy Blackburn from the Senior Marketing Group will be joining us. She was going to try to talk about the Senior Expo that was going to be held in a couple of weeks, but that's been a casualty of COVID-19. But there are some senior resources that are available for our community, and Kathy will talk about that today. In addition, we will have Wellspring from Spectrum Health Zeeland Community Hospital a little after 11 o'clock this morning, and Sarah Donkersloot will be in the studio to chat with the president of Spectrum Health Zeeland Community Hospital, Ron Lewis. But on the second Thursday of the month, we devote our first segment to what is called Ask the Judge, where a member of the district court or one of the prosecutors, or in this case, your magistrate, will answer questions about the legal system on a judicial matter. Now, keep in mind, we can't really talk about any particular cases before the district court that is ongoing right now, but we can talk about the justice system in general. And to do that in a Zoom connection, on the other end of our Zoom connection is District Court Magistrate Vern Helder. Hence the call that I like to make when he joins us, your magistrate. He's on the other end of our Zoom connection from the District Courthouse in Holland. Vern, good morning and welcome to WHTC.
Good morning. It's good to be here.
Glad you are with us. And of course, if you want to have a question with Vern, he'll be happy to answer it at 395-1450, 395-1450. Before we begin our conversation, I do want to make this statement right off the bat. Vern Helder is currently a magistrate with the district court here in Holland. He is running for a district court seat in the November general election, November 3rd, the seat that is going to be vacated by Susan Jonas. And so we will have a special segment with Vern on those his candidacy a little bit later on in the year. But today we will focus on judicial issues with Vern. And again, your calls are more than happy to be taken at 395-1450, 395-1450. Vern, first of all, as a member of the district court setup right now, things are, shall we say, very quiet at the courthouse, just emergency matters for the most part. But there is a plan to get the district court back into operations. Tell us a little bit about that plan, some of the highlights of the plan, some of the things that can be expected as we roll out and get back to some sense of normalcy in the wake of the COVID-19 situation.
Yeah, so as you indicated, the court is closed. All of our doors are locked. We have not had any in-court hearings since the stay-at-home order was put in place. We do want to get back to operating in a normal way. We have been operating using some technology such as Zoom. So anybody that's been arrested and has an arraignment, it's a video arraignment, which is what we did before. But we're doing all video arraignments for anyone arrested and is at the jail. Our regular arraignment day, which was Tuesdays, has not happened. So we're getting quite a backlog of cases. But the goal is to open the courts back up, continue to use some of these new technologies to maintain social distancing, but certainly some of the hearings we have to they have to proceed in court. And I'll give you an example. A small claims case is very difficult to do by Zoom. We can't default somebody if they don't show up by Zoom. We can default them if they don't show up in court. It's been very, very difficult for process servers to serve paperwork, so we're not getting defendants served, whether it's a small claims case or a general civil case or landlord-tenant. Of course, landlord-tenant's been put on hold anyway, but the court officers, if they go to the door of a party to serve them and they knock on the door, that person just simply isn't going to open the door. But the court has there's a 4-phase procedure to try to get the court to return to capacity. We have to submit local administrative orders. We as the court have to submit local administrative orders to the Michigan Supreme Court for approval prior to progressing to the next phase. So phase 1, we first of all have to have 14 days while the stay-at-home order has to be lifted, first of all. Now, we can go back 14 days, so that would be the stay-at-home order now is in effect through May 28th. It's May 14 today. If the stay-at-home order was lifted on May 28th, we would be back as long as the other criteria is met. We would be able to begin starting some court proceedings. We would limit attendance to no more than 10 in the court. That includes the judge, magistrate, court staff. The in-person hearings will be expanded to include non-lodged arraignments and other required in-person hearings. So some of the gating criteria is we have to have no COVID-19 cases or suspected cases with court personnel for 14 days. If there is a confirmed or suspected case, we can make sure that everything's, the facility's deep cleaned and disinfected and the employees have been self-quarantined. We have to have a downward trajectory of documented cases within the last 14 days. So far, we don't have a downward trend of documented cases, but we have to have a documented downward trajectory of downward cases within 14 days, or positive tests as a percentage of total tests have to go down. And then the third requirement is the stay-at-home order has to be lifted, and our healthcare facilities must be able to treat all patients without crisis care. So if we can meet all of those criteria, theoretically, we could begin hearings on May 29, and I believe May 29 is a Friday, but we don't have any court hearings scheduled. We won't know if the stay-at-home order is lifted until the 28th.
Yeah, it's a sort of everybody's on a waiting pattern in that regard.
Yeah. So the earliest under phase 1, the earliest time frame we would start would be June 1. That's the best case scenario. And then we proceed through phase 2, 3, and 4. 4 is when we return to full capacity. The earliest projected date for that would be between June 26 and July 10. So we're talking basically, even to get to that level, probably not until July.
Another 6 weeks. And of course, that's if we catch lightning in a bottle and, get some sort of herd mentality on a worldwide scale more than just maybe a local scale as well. Let me ask you a question, and maybe you can answer it, or maybe it's been answered by perhaps the state Supreme Court. We know about the constitutional guarantees of a fair and speedy trial. Well, you can get a fair trial. Speed right now might be a little bit different. How much of a concern is there in the judicial community about trying to meet these speedy trial situations when right now, you can't process, especially in a criminal case, proceedings in a timely manner right now?
Yeah, we're doing the best that we can as far as proceeding in a timely manner. I know that in some respects, the Supreme Court has issued an order that allows for a moratorium, if you will, for some time constraints. So if you were required to file an answer to a complaint, or you were maybe required to file, we'll talk about a civil case again, maybe required to file a civil case within a certain period of time to avoid a statute of limitations issue, those are all extended while the stay-at-home order is in place. So the courts have done some hearings by Zoom. The parties have to agree to do the hearings by Zoom. But I think at this point, it appears that both defense and prosecution are not I shouldn't say that concerned, but they're not concerned about getting them done within the statutory requirements. So I think everybody understands that time frame is suspended. Our hands are tied. We really don't have the ability or the authority to continue with the hearings, at least in-person hearings. But we're doing the best we can under the circumstances. There's none of us here that would like anything more than to get back to having cases heard in court and keeping up with our dockets. And, the district court in Ottawa County, and we have 3 court locations, Hudsonville, Holland, and Grand Haven. The district court meets all of the state's timeliness requirements every year. We're very diligent. We have a terrific court staff. Everybody works very hard, and we do everything possible to process cases in a timely manner pursuant to the guidelines set by the state.
If you got a question for District Court Magistrate Vern Helder, he'll take it at 395-1450, 395-1450. In your response, you brought up a point I had neglected, and I'm glad you brought it up. Statute of limitations. That has become in the news recently, involving the late University of Michigan team doctor who had reportedly or allegedly committed acts of sexual nature on Michigan athletes decades ago. And unfortunately for the victims, statute of limitations did come out. Now, I'm not going to ask you about that particular case, but talk about the statute of limitations, what that entails, what the judges have to do. They only work with the laws that's in front of them, but yet it's got to, that is a very dicey situation about dealing with statute of limitations.
Yes, it can be, because if you miss the statute of limitations, then you don't have a legal basis to proceed with any kind of a claim that you have, whether it's a civil claim or whether it's a criminal case. So you have to be wary of what the statute of limitations is. And the statute of limitations is vastly different depending on what kind of case you have. Some statutes of limitations are 2 years, some are 6 years, and then there's some types of cases or crimes that have no statute of limitations, so you can bring that charge at any time. Some of those statute of limitations have changed over the years. I'm not sure specifically about the U of M case or the doctors in the U of M case, but it's possible that under certain circumstances, certain crimes have the statute of limitations has been, there is no statute of limitations, I guess would be a good way to put it. But for a lot of cases, there are statute of limitations, and it's very important that you know what those are. For example, a medical malpractice statute of limitation is I don't know the exact statute of limitations, and probably depends on the type of case, but it could be as little as 2 years. Sometimes you have to give certain notices in order to be allowed to bring a lawsuit, sometimes with insurance claims, and there's all different kinds of cases, different statutes of limitations. So it can be very complicated.
If you got a question for Magistrate Vern Helder, he'll take it at 395-1450, 395-1450. Something that's come up to mind today, and hopefully you can explain it a little bit, what it does entail. And that is dealing with extradition. We have had a report today of a crime that has been committed on Holland's north side. It was a death that apparently is being ruled as suspicious, and a suspect has been arrested in South Bend, Indiana. What does extradition entail within the United States, from state to state? Who would hear the case? Would it be a district judge? Like, for example, if it was the other way around, a person, say in Indiana, accused of a crime, a felony, gets arrested in Ottawa County, would that be heard before a district judge or a circuit court judge? And what would be the criteria that a judge would have to be before they make a decision on whether or not to allow the suspect to go back to the state to face these charges?
Yeah, so I'm not sure if that would be heard in front of a district court judge or a circuit court judge, so I apologize for not knowing the answer to that. But really, the judge that hears the case, the only requirement is to determine whether the person that's been arrested is in fact the person that is subject to the out-of-state warrant, and they don't determine anything about the underlying nature of the case. It's just a determination as to whether that person is the person that's named in the warrant. And then there's government, or there's governors that get involved, and I'm just not sure of the entire process. But most people, to be honest with you, waive extradition. I would say the majority of people waive extradition because they know that they're going to get extradited, and they just have to go face whatever the charge is in the state that there's a warrant. I'm not sure if there's a warrant yet for the person that was arrested in South Bend. I did hear briefly about the alleged crime and the fact, and I heard just before we came on air that someone had reported that they arrested a person in South Bend, Indiana. So I don't know anything more about that. But the determination really is that person that is listed in the warrant, the person that is charged in the other state.
I was not trying to talk about that specific case, Vern. Right. But I just wanted to talk about the overall extradition process within state to state. When we get to international, that goes a little bit different. That goes into the federal books more than the state books, doesn't it?
Yeah, I'm sure that's a totally different scenario.
Yeah,
we don't get too involved with extradition. We don't get very many extradition cases. As a magistrate, someone might get arrested. And if we do the video arraignment, which we do if the judges are unavailable, we will see if they are willing to agree to extradition or not. If not, there's a governor's warrant that's issued, and it's a whole process. But it can delay the process by some period of time. And so if someone doesn't want to go back and face the charges right away, they'll take the steps to make the courts jump through all those hoops.
Yeah, the other thing, too, is that, say, for example, a person is wanted for felonies in several states and gets arrested in one state. It's not a judicial situation that would be a case of judge decides, okay, where this guy or woman gets a hearing and has to face the justice system, is it in one state or another? That's more of a prosecutorial situation than it is a judicial situation, I would think.
Yeah, I'm not sure about that. The person would have to face charges in all of those different jurisdictions. I'm not sure what order what order that would happen. If it's the oldest case gets tried first, or they get sent to that state first, or if it's whoever comes and gets them first. I'm not really sure.
Yeah, just sort of as a point of reference for the extradition process. I think one of the more notable cases where we had to have people extradited from a different state back to Michigan, and it was over a decade ago, the Janet Chandler case, where a number of the people that were arrested were in Wisconsin and other states, and they had to be or Pennsylvania, and had to be extradited back to Michigan to face justice in Ottawa County on that. That is the first thing that comes to my mind, Vern, in that regard, between intra-state or interstate, I should say, extraditions. But again, the point we're making here is the fact that we do have a situation today where we had a crime in Ottawa County and the suspect was arrested down in South Bend. While the district court, Vern, is closed to most proceedings in terms of not only in person, but many of the proceedings are on hold because of the COVID-19 situation, some of the duties that you normally perform as a magistrate, how much of that has been put on hold, and are you afraid about getting some of the backlog coming up on that?
So any in-court hearings been put on hold. So yeah, we will have a backlog as far as that's concerned. We still do search warrants. We do arrest warrants. Most of the search warrants are done electronically. We have a program called DocuSign, and we've had it for a few years now, and it was really set up so that we didn't have to have a fax machine and get a fax document at night, because so our judges and magistrates are on call once every 7 weeks is our rotation. So when we're on call for the whole week. We take any requests and it's mostly search warrants, not arrest warrants, but mostly search warrants after hours. And as you can imagine, that's mostly for blood. the ones that don't have to be obtained after hours, the detectives or deputies don't typically come to us after hours. Although, we've had some WeMet type issues, and, some of them are more urgent. But certainly a blood draw for a driving related offense is one of them. And so we set up DocuSign so we didn't have to use a fax machine. So they didn't have to call in the number, fax a document, sign it, fax it back. And DocuSign works really well. But since we've implemented that for after hours search warrants, the detectives also use it during the day. Now, more of them have been using DocuSign. For example, I am in Holland today, in the Holland District Court. We have the Holland Police Department right across the lobby. Most of the time, those guys, if they had a search warrant, would come over and talk to us, and we'd sign the search warrant. Now, even they have been doing it by DocuSign because we're limiting our face-to-face contact. So some of the responsibilities or obligations that we have, some of our duties we're able to do. Obviously, the hearings we're not. We are looking. I set up Zoom in my courtroom. We're getting ready to try to proceed using some Zoom hearings. We think most likely the traffic type hearings would be ones that will be easier to set up by Zoom, because for a traffic hearing, the person who receives the ticket is called a respondent. They're not called a defendant because it's not a criminal case, it's a civil infraction. But the respondent requests the hearing, so we have contact information, and so we can reach out to them and say, we are going to do this hearing by Zoom. Are you willing to proceed in that fashion? If not, then we would reschedule it for a date later when we're open. So,
Vern, let me get to one call before we button up our program today. Good morning. You're on the line with Magistrate Vern Helder.
Good morning. It's my understanding that when there's a felony, or especially a murder, that it goes to a district court first, and then to see if it's sufficient evidence to go to circuit court. My son was murdered 25 years ago, and they brought in two men with the one that actually was convicted and jury tried and found guilty, but two men were brought in and went through terrible, terrible things in the trial, and without really sufficient evidence. And I wonder how they can bring them into circuit court without going through district court first, just not good evidence, but try to bring in two other ones, and they had to go through terrible things for a long time.
Yeah, let's get his answer. Get his answer real quick, Vern.
Yeah, that's a very good question. First of all, you have my sympathies for your son. I know it was 25 years ago, but that's a very tragic thing to go through. Every criminal case starts in district court. Every criminal case. So the district court on a felony determines whether there's sufficient evidence to bind them over in circuit court to have a trial in circuit court or have the case proceed in circuit court. But every criminal case starts in district court. So he's exactly right.
All right. Appreciate the call. Thank you very much for that. Vern Helder, want to thank you very much for joining us today on WHTC's Talk of the Town for the Ask the Judge segment on this Zoom conversation. Audio will be on our our website at WHTC.com in a few moments, and then we'll have the video on our Facebook page, 99.7 and 1450 WHTC a little bit later on today. Vern, thank you very much. Look forward to chatting with you again soon.
You're welcome. It's my pleasure. Thank you for having me.
Thank you very much, Vern Helder on 99.7 and 1450 WHTC. CBS News is next on the hour.